So imagine this. You live in a country where the law that applies to you could change based on who you are, where you're from, or even just the type of contract you sign. And I'm not talking about some weird legal thought experiment. This is the reality in Sierra Leone, a nation that literally operates with two different rule books. We're going to dive into this fascinating tale of two laws.
It sounds a little crazy, right? How can one country possibly function with both English common law and traditional customary law existing side by side? That's the central puzzle we're going to unpack in this explainer.
First off, let's get our terms straight. What we're talking about here is called a dual legal system. It's basically when two totally different legal frameworks, in this case English general law and local customary law, are both officially recognized by the state. They're supposed to work in parallel, but as you're about to see, it is way more complicated than that. Now, you might think this is some kind of informal, unspoken arrangement. But nope, this whole dual system is officially written into the fabric of the country, starting with the highest law in the land, the Constitution.
That's right. If you look at Section 170 of the 1991 Constitution, it explicitly gives the green light to both systems. But, while the Constitution tells you what the law is, another document lays out the really crucial part, how it all works.
And that how is all laid out in the Courts Act of 1965. Think of this as the official playbook for the whole dual system. It sets the ground rules. When can you use customary law? What can it actually cover? And this is the big one, who wins when the two legal systems clash? This act is basically the referee in a very, very complex game. And that brings us right to the heart of the conflict. Because even though both systems are officially on the books, they are not treated as equals, not even close. There's a really clear hierarchy at play here.
Okay, so here's the fine print. Section 76 of that Courts Act puts some major roadblocks in front of customary law. For a court to even consider it, the rule can't be repugnant to ideas of natural justice, whatever that means, and it can't clash with any official laws. So, customary law has to pass these repugnancy tests before it even gets a hearing.
And the impact of this is, well, it's massive. This quote from our source material really cuts right to the chase. The author argues that these tests are so restrictive, so subjective, that they basically make customary law useless in the country's main courts.
So, the really crucial question is, who gets to decide what's repugnant or incompatible? Well, it's judges, who've been educated and trained exclusively in the English legal tradition. Our source points out that this creates an innate professional bias, which makes it way more likely that they're going to favor the system they know, the system they trust.
Okay, so we've seen the power imbalance in theory. But how does this all play out for the average person on the ground? Who actually has to follow which set of rules?
This table really just lays it all out. General law is universal. It applies everywhere to everyone, no exceptions. But customary law? It's much more limited, both geographically and demographically. It mostly applies to native communities out in the provinces, but not in the capital city, and not to non-natives. You can see the power disparity right there in the scope.
And this is where it gets really personal. What if you're a native person and your default legal system is customary law, but you find yourself doing something that's governed by general law?
Well, the Courts Act has an answer for that. If a person whose life is typically governed by customary law enters into a transaction under the English system, say they sign a formal written lease or get a monogamous marriage license or write a will, then by that action, they have chosen to be governed by the English system. For that specific issue, they give up any protections they would have had under customary law. They've essentially opted out of their own tradition.
So when we pull all these threads together, a pretty clear and frankly uneasy picture starts to emerge about the relationship between these two legal worlds.
If there's one thing to take away from all this, it's this. Sierra Leone's dual system is not a balanced partnership, it's a hierarchy. From the repugnancy tests decided by English-trained judges to its limited reach, customary law is consistently put in a secondary, subordinate position to the general law that was inherited from the colonial era.
And all of this leaves us with a final, really important question. This kind of structure, which you see in a lot of post-colonial nations, it carries the weight of its history. It really forces us to ask, when one legal system is indigenous and the other was once imposed from the outside, can they ever truly coexist as equals?